learned friend submissions and my submissions about who's expert and whose expert is correct or whose one's medical opinion is of greater validity, you would almost be in a situation where we were in a trial where you were cross-examining two experts and running two experts' evidence against each other. As in expert against expert, not even expert against expert in respect of Mr. Carrim himself. The only reason I point to that is that if that's the Commission's real concern, then the elephant in the room is they think that the doctor is a liar, and they have the weaponry available to them to test whether he's a liar. And all these inaccuracies, whether they're of a material kind or not a material kind, I see Chair is getting ready, maybe I should stop.
Please, you overdo this thing of reading what a person does. I mean, should I not lean over? Should I not place my hand on my file? Please, Mr. Premier.
Oh, sorry, Chair, I thought you were going to engage me on what I was saying. That's why I preemptively stopped. I also have the other problem when the judge is trying to intervene and I don't then yield.
I remember at the Constitutional Court you reacted to two of my facial expressions.
Yes, indeed. But I don't mind that because you found for me on that occasion, so that's fine, Chair. Unlike what happened in the interdict yesterday, but that's besides the point. Chair, what I'm saying is that if this doctor is so unreliable, or his evidence is so open to doubt and to question, why on earth would this doctor under oath volunteer himself to come and give evidence and be cross-examined under oath? The approach of the Commission, with all due respect, has not been to take a benign or neutral position towards Mr. Carrim, the deponents of Mr. Carrim's affidavits, and even the treating doctor. It's been that, and I'm speaking in forceful language, but I preface what I'm about to say with the fact that my learned friend didn't put it in these terms, but this is the conclusion, and we must call it out for what it is. In their view, the evidence leaders' view, Mr. Carrim is avoiding accountability at all costs. He's using the deponents of the affidavits and treating clinicians to aid him in order to do so. And that's why they want to unpick, with all due respect, the most direct medical evidence in front of the Commission in order to go after Mr. Carrim. But the one thing they haven't done is they haven't called the doctor to be cross-examined by them, and he's volunteered himself to do so. So that's why this weird world in which we exist, with all due respect, is a difficult one for Mr. Carrim's legal team to have to engage in, because even when the doctor volunteers himself, instead of bringing a rebuttal witness to directly deal with his clinical views, which is a possibility they could have done, or by calling him through a subpoena to come give evidence in camera and be cross-examined, they want to put up all kinds of geolocation data and CCTV footage to impugn the doctor's medical views through the back door where there's no clinical basis to do so.
No, Mr. Pramit, I think it's grossly unfair that you would formulate the position of the evidence leaders to impugn the medical opinion. They are lay people. They're lay people, they could never pretend to do that, and I've not understood them to be doing that. That is different to speaking to the facts alleged by the doctor. When the doctor says the hospital protocol is that you can only leave in two circumstances, that's not a medical view that he has expressed. He's alleging a fact, and it's relevant information to be brought to the attention of the commissioners through the evidence leaders. And the geolocation material, as Ms. Hassan says, what has always been the impression is that Mr. Carrim is in hospital. He's confined to a hospital, right? And once there was information that, in fact, he doesn't spend all his hours in a hospital, that's relevant information to be brought to the commission. So you have absolutely no basis to criticize the evidence leader's position as being to impugn the medical opinions of the medical conclusions and opinion of the doctor. I would be shocked if that's what they were doing.
Me too, with all due
My
respect.
first question would have, and that's not what is in the papers. My first question to Ms. Hassim would have been, on what basis? In the same way, in fact, that I would like to ask the question, the deponent to the replying affidavit is a lay person. On what basis could she pretend to answer the Commission's expert views, as you have referred us to a
Yes.
paragraph, right? Is that an answer really in response to the concern raised by Ms. Hassim that there is no reply or answer to the Commission's expert? So let's not fudge things for whatever purpose, we're seeking to achieve. As I see it, or as I understand it, the simple position is this. There are certain facts that have been relied upon by the deponent to the affidavits of Mr. Carrim, supported by the doctor's affidavit. All that has happened is to answer those factual or to raise issue with the facts as set out, and none of it speaks to the medical conclusions. I differ with you there. Maybe my co-commissioners agree with you, but I differ with you. I do not see that.
I actually agree with Commissioner Baloyi. What the evidence leaders have done is to say Mr. Carrim must be subjected to an assessment by an independent doctor. And that's exactly because they, as evidence leaders, cannot purport to contradict the Mr. Carrim's doctor's opinion. That is why there's this insistence on let Mr. Carrim be subjected to an assessment by, it would be that independent doctor that would counter all of the clinical conclusions reached by Mr. Carrim's doctor. So at this stage, the point you make has not been reached, at least not on my understanding.
Well, but that...
yes.
Sorry.
But of course, a point is made, but on what Commissioner Baloyi refers to as facts. A point has been made that with regard to those facts, even what Mr. Carrim's doctor says, there has been a shifting
Yes.
of the goalposts, even by the doctor
Yes.
himself. That's a factual issue, and the evidence leaders are perfectly entitled to challenge the doctor on that.
I accept that, but then I would ask, my next question would be to what end and to what purpose? Because on the question of factual discrepancies, both of the deponents to the affidavit full square deal with the circumstances under which they were expected to depose to affidavits and the pressurized circumstances that they had to deal with various issues. And that's explained at pages 75, 76 for the one deponent, and with the other deponent, specifically on the medical records issue, you'll find that at 84, 85, and 86. So if there's an issue about the facts, so to speak, and the conclusions or the inferences that the commissioners are being invited to make as a result of these so-called inaccuracies, there's actually an explanation.
They are not so-called. They are inaccuracies, and Mr. Carrim's case, as we sit here, actually accepts those, that they are in fact inaccuracies. Hence the shifting of goalposts. So they are not so-called.
I withdraw the word so-called. To the extent that there are inaccuracies on the papers, they're dealt with fully, and the surrounding circumstances around how those inaccuracies arose are fully dealt with. It's not uncommon in urgent applications, for example, that sometimes a deponent doesn't fully remember what it is they otherwise ought to have remembered. And it's only when they are advised of something in an answering affidavit that then in the reply they give the fuller account and context. Because of the pressured circumstances in which they were deposing. So all I'm saying is that let's accept the inaccuracies are for what they are. It's maybe unfair is too strong a word, but it's unfortunate to draw any adverse inference by the mere fact of those inaccuracies in circumstances where there's also an attempt to explain how those inaccuracies arose. But to the extent then those inaccuracies relate to movement and what can be said about Mr. Carrim's medical condition as a consequence of the facts of that movement, it's not a purely factual inquiry, because what the doctor says in terms at paginated page 44 of the papers, at paragraphs 49 and 50, is he says that the danger in analyzing the facts of those movements would potentially lead you to draw an inaccurate clinical conclusion, because the fact of those movements is not necessarily antithetical to the treatment he's receiving. In fact, in another part of the affidavit, he actually says that it might form part of the therapy process. So I accept what Commissioner Baloyi puts to me. Commissioner Baloyi rightfully says that they're not impugning his clinical diagnosis, they're just relying on these factual issues to say there's a problem here, and I'm being loose in my language. And so let's accept that there's a problem here, and then say what's the clinical opinion in respect of that so-called problem that's on the papers in front of you and not challenged. And that's what the doctor warns the commissioners from drawing an inappropriate conclusion on, that those mere facts are elevated to considerations that impugn, or not even impugn, that open to doubt the clinical diagnosis, even if that's not the direct intention of disputing those facts. And what the doctor's evidence is regarding those facts is that they are what they are, and they might be what they might be. But you can't draw in based purely on those facts. You must be very careful in what conclusion you draw, and I'll put it no higher than that. So I think that's where Commissioner Baloyi, I was dealing more with the conclusion and the conclusions to be drawn from those facts, whereas I think, Commissioner Baloyi, you were focusing on those facts themselves, and I hope I've attempted to answer you in both respects why there's a danger in the exercise that we were just going through. Yes. Oh. I thought Ms. Matlingwane had something for me. She doesn't. So that's on the issue of are we impugning or are we not impugning, and to what extent are we impugning. Just, Commissioner Baloyi, one thing that you raised, which is correct, the deponent is a layperson. What business does she have engaging with the report? If I'm not mistaken, there has or should have been a signed confirmatory affidavit from the treating doctor in respect of the content of the replying affidavit. And even if it doesn't say it in terms, I consulted with the doctor on X, Y, and Z, and he tells me, here's the response. I would ask, in a generous reading of that replying affidavit and the fact that it's confirmed by the doctor, that the so-called medical responses are medical responses from a non-medical person, but confirmed by the medical person themselves. It's not just the deponent offering her own opinion or thoughts influenced by the legal team or anybody else. So that, Commissioner Baloyi, I hope is a satisfactory response on those particular issues. Chair, I think I've dealt with everything that I need to. Might I just take an instruction, please? Oh, yes. I'm indebted to Ms. Matlingwane. Commissioner Khumalo, back to our debate about the timeline and the date and when it started and everything else. The reference I had in mind starts on paginated page 36. It's the heading you'll see there under paragraph 18. And then through you, Chair, Commissioner Khumalo, over the next page, well, it starts at the bottom at paragraph 22.
18 says exactly what I said.
Yes, agreed. And then I'm asking you to read 22 at the bottom of that same page. particularly where it says health conditions appear to predate the commission. It then talks about his history, and over the page on page 37, I would say that I would draw your attention to the last line, starting 3 lines from the bottom on page 37, paragraph 22. It starts with, I emphasize this because the underlying blank, blank, blank. I know that might not be satisfactory to your question. I'm just giving you the reference that I had in mind when I answered your question.
It's also factually incorrect.
Thank you, Chair. I'm indebted.
Thank you, Mr. Premier.
Chair, may I ask a clarity, please, before we break up? In passing, you said that we must give by the close of business tomorrow the transcripts.
Just on your and my debate the last time on the power issue.
Yes.
Or lack of power, as you
Yes.
argued. Yeah.
Yes.
Yeah.
Is
Just
it all
on
right
that,
if...
Because, yeah, in the context of you talking about there having been no resistance, as I understood you, by Mr. Carrim, to the possibility of voluntarily agreeing to an assessment. That's the context.
Yes, yes. Is it okay if we mark the transcript?
Yes, yes, yes.
Okay.
Please. Yeah.
Thank you.
Thank you to both counsel. Obviously, we can't make a ruling now, and I'm loath to give a deadline by which a ruling will be made. Let me just say, a ruling will be made on a date that will be announced by writing to Mr. Carrim's attorneys and also being publicized in the manner in which our spokesperson ordinarily does. We continue on Monday, 9:30?
9:30 on Monday, yes, Chair.
Yes. Let's adjourn and resume at 9:30 on Monday.